Good morning. It is February 21st, and we are having our continuation of Public Health and Minority Health Disparities Subcommittee on the Assisted Outpatient Treatment, House Bill 576. Yesterday, we had the walkthrough of the amendments. I wanted to talk about one thing that we want to add back from the bill last year. I think it was struck, but I wanted to make sure that we had that we could add it back. It was the language around protections, the same protections of civil or criminal procedure. And since we did the full walkthrough yesterday of the amendments, I was going to turn it over to Aaron to talk about the proposal of reinstating that language, and then ask for a motion on the amendments so we can have the discussion. Aaron, if I can turn it over to you just for this one piece, and then we'll open it up.
Yeah, sorry, you had said 106A06B4. And I'm looking and I'm not seeing.
So it was 10.6 10.6A for B4 in the House Bill 823.
Oh, okay.
So in House Bill 576, it would be 7604. See.
I think it's 106A06B3 is the language
as special funds
that references rules of civil procedure.
Yeah, so in last year's bill, there was a provision that said the subtitle may not be construed to abridge the rights of a respondent, and any right normally afforded to an individual in a civil or criminal matter shall apply. That was inadvertently left out or struck from this year's bill, in the opinion of the committee, and would like to reinsert that language.
So, can we conceptually adopt that as part of the amendments for the purposes of discussion?
Yeah, can we move the amendment so we can discuss it?
Second.
All right, it's been moved and seconded. Thank you. So, and as I mentioned to our members, conceptually, we're looking at reinserting that language that was inadvertently struck. It's not part of the reprint, but it's identical to the language from the House Bill 823, which was voted out unanimously by this committee. All right, Delegate Chisholm.
Thank you, Madam Chair. Can somebody give me a real world example of what we're talking about on this amendment? How would it apply? What are we trying to achieve with the amendment?
I'm going to ask, as I called her, Eagle Eyes Alston, Delegate Alston, who was the one who noticed that we had inadvertently struck that provision, because she was having the conversations last year as well with the Office of the Public Defender and with Judiciary. Delegate Alston, are you available?
I am. I just hope you all can hear me. I'm walking back from the Senate. Can you hear me okay?
We can hear you.
Okay, great. So the reason we put that language in is because sometimes these cases can have criminal collateral consequences, meaning you have a person who has a mental health disorder, they are acting out, the police don't really want to arrest them because they recognize it as a mental health issue and not a criminal issue. And when you go into civil court and you need to discuss these things, if you start talking about the crimes you've committed, like now you're lucid and you're remembering, but you weren't in a good state at that point. We don't want people to be charged with crimes when they're trying to get help for their mental health issues. And so by giving them the same rights that a criminal defendant would have. They would have the right to not speak, right? To not say, yes, I was in a mental health crisis and I hit someone. If you don't answer that question in a civil context, not answering it can actually be used against you. But as a criminal defendant, if you don't answer it, it cannot be used against you. So what we're trying to do is protect people, because the whole purpose of this is for it to not be criminal, for it to not have criminal consequences. So instead of trying to figure out how to language all of that, the easiest thing to do was to give them all of the rights that a criminal defendant would have. And I'm sorry, I'm out of breath. And I hope that answered the question.
Yeah, so I guess in short, because you're not mentally able to understand your Miranda rights or where you are at the time, that you don't want it to be, I guess, you don't want it to be given up because you have no ability to understand what's going on at the time, and you don't want it to be used against you in the court of law at that time, and then put you into a criminal problem rather than getting help. Am I correct?
Yes, that's the general concept.
Okay.
And I see hands from Keith Lotridge from the Office of the Public Defender and also from Judge Morrissey. So I'm going to go ahead and call on Mr. Lotridge and then Judge Morrissey to give us context too, because obviously the Office of the Public Defender and Judiciary were helping us work through this process last year when we were working working with the work group.
Hi, and thank you. Keith Lotridge, Office of the Public Defender. I think Delegate Austin actually got it correctly, but I was just trying to give you a hands-on example. In a civil trial, even if I don't want to call my client and I don't put them on the stand, the other side can put them on the stand. And when you put someone on the stand, especially someone with mental health, even if they don't want to talk about a particular issue, they get exposed to, well, all kinds of things. You can't control what happens when your client is on the stand when opposing counsel can question them. By applying the criminal rules, my client, if we're in a civil setting, can't be put on the stand. And even if he were put on the stand, we could limit what questions he were asked. So it's really the only way to protect someone who has criminal liability in a civil setting. And it is not something that's often done, but it is done it should be done in these matters. I think that's pretty much it. So I think Delegate Austin got it. I just wanted to double down on that. And I thank the committee for adding this back in.
Thank you so much. Judge Morrissey.
I'll be very brief, and good morning, members of the subcommittee. Delegate Chisholm, a real life example would be if a domestic violence order is brought in and the respondent's already been incarcerated because there was an assault involved. And so when the respondent comes out, all judges advise the individual that this is being recorded, that they're under oath, that the option of not testifying, but if they do choose to testify, that anything that they say can be used in the pending criminal matter. And we kind of discourage them talking at that point because they typically don't have counsel at that point. So if that helps at all.
No, that was excellent. Thank you so much.
And thank you both for giving us context, real world experiences, and demonstrating that this seems like a good thing on all sides. Delegate Lewis.
Thank you, Madam Chair. Good morning, colleagues. I just wanted to say two things, if I may, Madam Chair. I have one statement and one question. First, thank goodness for lawyers. I just want to put that on the record. And secondly, I wanted to make sure I understand by restoring the patients, and I keep calling them patients.
So they're called respondents.
Respondents, but I read the responding to a court order, and I get that in legal terms, but being grounded in healthcare as I am, I do think of them as people who need healthcare. But anyway, the respondents, making sure we protect their right not to incriminate themselves seems to me incredibly important. And I just want to make sure we're talking about protecting their basic, like, Fourth Amendment right to due process, correct? The right not to self-incriminate. That's a fundamental right in the US Constitution. So we wouldn't want to touch that, correct?
Correct. And this is the petition process is a civil process, but we actually want to ensure the highest standards of protection. So we're actually created with this amendment returning, we are creating the highest standard of protection. Delegate Alston, do you want to add?
Yeah, I was just going to say one of the differences between criminal and civil law is that if we are in the civil context, they would still absolutely be able to say, I'm going to take the fifth, right? You can always do that. The problem is in the civil context, that can be, the judge can take a negative inference. In fact, they can take every negative inference that comes from you not answering that question. And we don't want that, because then it kind of looks bad. But in the criminal context, if someone chooses not to testify because it could incriminate them, there's no negative inference drawn from that. And that is the real distinction. So whether we put it in or not, they can still always assert it. This is America. We can assert our right to not incriminate ourselves. But the distinction is, because we want them to get the help, we don't want the judge looking at them negatively for choosing not to answer certain questions that could incriminate them. And I think that's, for me, that was one of the big things, because we want people to get the help and we don't want to discourage them from participating because they're afraid.
May I have a follow-up, Madam Chair?
Yes, go ahead.
Thank you so much. Thank you, Delegate Alston, and to Judge Morrissey and Mr. Lottridge. But just further clarification, I've spoken with advocates from other states. I'm thinking particularly of an advocate from New York City who just shared with me a real fear and worry about AOT. And one of the critiques that she held very strongly was that AOT would criminalize people who really are sick and need healthcare. They need mental, behavioral, physical healthcare, and they need shelter and good nutrition and all the other things. She said by implementing AOT, you basically criminalize this whole class of people. And I want to make sure that we can answer those critiques. I just want to make sure that this amendment we're restoring will truly make this proposal healthcare forward and not criminalize people. I really want to make sure that we're not making the same mistake that they might have made in New York.
Thank you, Delegate Lewis. And Delegate Alston, if it's okay, I'm actually going to ask if you'll respond, because this amendment that we're restoring is just a piece of the overall protections that we worked really hard to ensure, because we shared the same concerns. I think the entire work group shared those concerns, and this is a piece of a much larger set of protections that are implicit in the bill.
Absolutely. And thank you, Madam Chair, for letting me respond to this. So I think the entire work group unanimously agreed that we don't want this process being criminalized. So we've tried to take every step we could to make sure. We've put in there that there are no collateral consequences from this. It can't be used against you in any subsequent types of proceedings. I believe we sealed the records. So people can't just go into court and see what it is. And it's civil. It's going through the civil court. But even though it's going through the civil court, we wanted to make sure people were protected. So we amended the Public Defender Act so that the public defenders could represent them, because we recognize that there may be some rights that people may lose. And we wanted to make sure that if they couldn't afford a lawyer, they could have an attorney, and they always can get private counsel. And they'll have all of the resources of the public defender's office at their disposal. So I think we've done I think people might get freaked out because they see public defender and they see the word criminal, but these are actual added protections to make sure that they're not criminalized, not to put them in the criminal realm. This is a civil proceeding. It's going forward in civil court. There's no risk of incarceration, and it's out patient treatment, like it's outpatient treatment. And I think that's something that people are also getting confused with when we listen to some of the testimony, people talking about forced hospitalizations and forced medication. This is outpatient treatment where the actual respondent will have an opportunity to voluntarily agree, to challenge the whole process itself, to present their own witnesses and their own experts. If they have a actual advance directive, that directive will be honored. And so I think these are all very important protections that we've made sure will be present for the people who are who may go, the small group of people that we anticipate will go through this program. Our focus is to get them help and to get them treatment and to not criminalize them. And I think we went through every possible thing we could think of to give them that, which is why we didn't want to invent language. We took the existing rules of procedure because those rules apply to everybody in civil cases, and those rights apply to everyone in criminal cases. So I think that was the right balance that we tried to strike. And, you know, if we didn't get it right, then there's always next year where we can come back and fix it once we see it in life and in action.
Thank you, Delegate. Thank you, Madam Chair.
So we have a motion on the amendment that's been moved and seconded. Are there any further questions from the members? All right, all in favor of the amendment, say aye.
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 Anyone opposed, go ahead and raise your hand in the chat. All right, the amendments pass unanimously. Do we have a motion on the bill?
Move the bill as amended.
All right, it's been moved and seconded. And so let me open it for discussion. I have a couple of hands up. Ms. Tenney and then Judge Morrissey.
Hi, thank you so much. Many of you probably don't know me. I'm from New York originally. I've been working on this since 1995. I'm a research psychologist. I was inside of the Office of Mental Health when Kendra's Law was passed. The reason that it's called assisted outpatient treatment was because it was based on the Department of Health's tuberculosis program of delivered observable treatment because the involuntary outpatient commitment was considered too harsh. Most of my work looks at the racist and classist and gendered ways in which Kendra's Law and involuntary outpatient commitment across the country now has been carried out. But also really looking at the fact that there's zero biological evidence for any psychiatric diagnosis and tremendous biological evidence for the damage that psychiatric treatments, electric shock, drugging, surgeries, aversives cause. In the Senate hearings yesterday, one of the questions that came up was, would electric shock be something that conceivably could be court ordered on somebody? And the answer was yes. And so these things are not far out. Electric shock is the current favored practice during pregnancy because you're not allowed to give some of the psychiatric drugs. And actually somebody in the testimony yesterday also brought up that somebody was forced to have an abortion to maintain being—
Miss Tenney?
So my question is,
I need your question.
Okay,
please.
so my question is for each of you to seriously consider, because there's no actual biological testing, and even if there was, like in cancer where people
Miss Tenney, I need your question, please.
Are you willing to go under an injectable for 6 months on the idea that somebody may be incorrect about what it is that the diagnosis is? Are you willing to go under electric shock because somebody may have made an incorrect diagnosis about this? And then when you compare that with the issues around race and class and gender and other kinds of social things, if you want to call this a program of social control, call it a program of social control, but don't call it a program of treatment. And I think that that's the thing you have to each ask yourself. If somebody was making this assessment about you and was going to put a 6-month injectable into your body that you knew was going to shorten your life by 25 to 30 years, that's
our bell's rung.
Miss Tenney, we have to leave. I have to let the members go.
Okay, well,
we do have a motion
on this
bill.
Are you willing to have that happen to yourself?
Miss Tenney, we have heard your comments and we appreciate your comments. To my members, we will
move for the order of the day so we can vote this bill.
Second, let's vote.
All right, it's been moved and seconded. All in favor, say aye.
Aye.
Anyone opposed? Any of my members opposed? Go ahead. Delegate Hutchinson, I see your hand. Any other members, if you want to raise your hand? Delegate Riley, I see Delegate Hutchinson.
I'm gonna vote for this, but I don't like the way it just ended. I don't like forcing bills through. I really don't. Hopefully we have a long discussion. I like the bill, but I don't like when we have four hands up and we push a bill is not good for the public, in my opinion. But I'll vote for the bill.
I'm sorry, I couldn't see the hands up. I am so sorry. I did not know there were other hands still up. I apologize for calling for the order of the day if that was the case. I do deeply apologize for that.
No worries. I'm just trying to make sure the public has got their say.
Madam Chair,
Yes, Delegate Hutchinson.
I would just like to explain my vote in that, as you know, in testimony, I have brought up issues about the smaller counties. I've reached out to Midshore Behavioral, and they were having a meeting to discuss the implications in 3 of my counties. I've reached out to the Lower Shore Behavioral Health. So until I get those answers, I'm going to vote no. That may change in committee, and if we make it to the floor, it may change there, but I need to make sure I'm looking out for my smaller counties.
Thank you very much.
I do like the bill.
Delegate Rosenberg, Delegate Riley, I saw your hands were up. Was that from the vote or was that for a question?
I would
Well,
like to
mine
say
was
something.
from the vote, and also, ditto from what my colleague had just said. May change my mind, in committee for full vote or on the floor, but just need a little bit more time. Thank you.
Absolutely, I appreciate that. Delegate Rosenberg.
Ditto, there will be further opportunity to discuss the bill before the full committee on Friday. So, and we've
Absolutely.
had a significant discussion as is, so, but we understand people's concerns, or I do, certainly, and I know, sure the committee does, subcommittee does.
All right, thank you very much, Delegate Rosenberg. I'm going to go ahead and adjourn so that members can get to the floor.
Motion to adjourn.
Thank you. Motion second. Before I do have I'm making a note that I had hands raised from Judge Morrissey, Janet Edelman, Katie Rouse, and Morgan Mills, because I do want to reach out to you and find out if you have additional concerns. So with that, we are adjourned, and members go to the floor so they don't get mad at me for you being late. Thank you.